Good afternoon. Today I'll be discussing Batas Pambansa Bilang 22 or the Bouncing Checks Law, including when it's punished, the elements, the penalties, and also its difference from estafa. Let's begin. A check often serves as a substitute for money. It allows transactions to proceed without money actually switching hands. However, the convenience afforded by the checks need to be balanced with the threat which unfunded or bum checks pose on commercial transactions. These checks are deemed to have pernicious effects on the integrity of banking and other financial transactions and therefore injurious to the public interest. To curb the practice of issuing worthless checks, Batas Pambansa Bilang 22 was enacted. So what are the acts punished? First, making or drawing and issuing a check knowing at the time of the issue that the offender does not have sufficient funds in the bank. So here, the drawer of the check knew that at the time of the issuing of the check, he has no funds in the bank. The second one, the failing to give sufficient funds or credit with the drawee bank such that when the check presented within the period of 90 days from the date appearing on the check, it was dishonored by the drawee bank. So here, at the time of the issuance of the check, the drawer has funds in the bank. However, the crime will arise because he failed to make good the check or he failed to keep funds to the said drawee bank within the period of 90 days such that when the check was deposited within the 90 days, it was dishonored by the drawee bank. So here are the elements of Batas Pambansa Bilang 22. That a person makes or draws and issues any check, that the check is made or drawn and issued to apply on the count or for value, that the person who makes or draws and issues the check knows at the time of the issue that he does not have sufficient funds in or in credit with the drawee bank for the payment of such check in full upon its presentment, and that the check is subsequently dishonored by the drawee bank for its insufficiency of funds or credit, or would have been dishonored for the same reason had not the drawer, without any valid reason, ordered the bank to stop payment. It will be noted that Batasang Pambansa Bilang 22 requires that a person who makes or draws and issues a check must have knowledge at the time of the issue that he does not have sufficient funds in or credit with the drawee bank. Section 2 establishes prima facie evidence of knowledge of such insufficiency of funds or credit. The making, drawing, and issuance of a check, payment of which is refused by the drawee because the insufficient funds in or credit with such bank is prima facie evidence of knowledge of insufficiency of funds or credit when the check is presented within the 90 days from the date of the issuance of the check. So, what are the exceptions? One is when the check is presented after 90 days from the date of the check, and another is when the maker or drawer pays the holder thereof the amount due thereon or makes arrangements for payments in full by the drawee of such check within 5 banking days after receiving notice that such check has not been paid by the drawee. The presumption of knowledge of insufficiency of funds or credit does not lie when the check is presented after 90 days from the date of the check because Section 2, which establishes the presumption, requires that the check be presented within the 90 days from the date of the check. The element of knowledge of insufficiency of funds or credit is not presented and therefore the crime does not exist. When the when the drawer either number one, pays the holder of the check the amount due thereon within 5 banking days, and after receiving notice that such check has not been paid by the drawee. And number two, makes arrangements for payment in full by the drawee of such check within 5 banking days after notice of non-payment. Remember that prima facie evidence does not arise where notice of non-payment is not sent to the maker or the drawer of the check. If notice or non-payment by the drawee bank is not sent to the maker or drawer of the bum check, or if there is no proof as to when such notice was received by the drawer, then the presumption of prima facie evidence, as provided in Section 2 of BP22, cannot arise, since there would simply be no way of reckoning the crucial 5-day period. So here is an example. The question here is, what if A issued a check to B in favor of an obligation? B was, however, a businessman who was too busy, so he was able to deposit the check 120 days from the date appearing on the check. This is beyond the 90-day period. The check presented was dishonored. Notice of dishonor was sent to A, and A failed to make good the check within 5 banking days. Can B still file a case for violation of BP22 against A? So the answer here is yes. B can still file a violation of BP22 against A. This is because for as long as the check is not yet stale, the check deposited and it was dishonored, violation of BP22 is committed. Here, the check was deposited 120 days from the date appearing on the check. The fact that it was deposited beyond the 90-day period would only mean that there is no longer prima facie evidence of presumption of knowledge of insufficiency of funds. However, such prima facie evidence, presumption of knowledge of insufficiency of funds, can be proven through other evidence, so still the violation of BP22 is committed. The Supreme Court said that for a check to be stale, it has it becomes stale only when it is deposited beyond the 180-day period or a period of 6 months. So when you deposit a check that is beyond 180 days from the issuance of the check, then it becomes a stale check. So we go now to penalty. The following are the alternative penalties imposable under BP22. Number 1 is imprisonment of not less than 30 days but not more than a year. Number 2, a fine of not less or more than double the amount of the check, and a fine that shall in no case exceed 200,000 pesos. And third is both such fine and imprisonment at the discretion of the court. So in the case of Sagigit versus People of the Philippines, it was held that Administrative Circular 12-2000 does not remove imprisonment as an alternative penalty for violation of BP22. The judges concerned may, in the exercise of sound discretion and taking into consideration the peculiar circumstances of each case, determine whether the imposition of a fine alone would best serve the interests of justice or whether forbearing to impose imprisonment would depreciate the seriousness of the crime, work violence on the social order, or otherwise may be contrary to the imperatives of justice. And third, should only a fine be imposed and the accused be unable to pay the fine, there is no legal obstacle to the application of the revised penal code provisions on subsidiary imprisonment. So in this case, petitioner here were first-time offenders, and the court said that since they are Filipino entrepreneurs who presumably contribute to the national economy and had brought the appeal believing in all good faith, that although they had believing in good faith that they had mistakenly issued a check and they had not committed the violation of PP22. Otherwise, they would have simply accepted the judgment of the trial court and applied for probation to evade a prison term. In the past years, so there have been two important developments regarding BP22. The first one is the shift in policy as announced by the Supreme Court in its administrative circulars. So it's SCAC number 12-2000 and the other one is SCAC number 13-2001. So towards the imposition of a fine only and not imprisonment for violations of BP22. The second are the decisions of the court holding that the prosecution in BP22 must establish that a written notice of dishonor was actually received by the drawer or the maker of the dishonored check. In these administrative circulars, the Supreme Court declared that imposing the penalty for violations of BP22 The court should follow the policy of redeeming value human material and preventing unnecessary deprivation of personal liberty and economic usefulness with due regard to the protection of the social order. In that regard, in lieu of imprisonment, a fine in an amount equal to double the amount of the check involved has been deemed an appropriate penalty for violation of BP22. Subsequently, though, through Administrative Circular 13/2001, the Supreme Court clarified that it did not intend to remove the penalty of imprisonment, but that the courts should reserve imposing imprisonment as a penalty for serious cases when the violation of BP22 was committed in such a way as would negatively affect the social order. With regard to the second development, failure to establish that a written notice of dishonor was actually received by the maker or the drawer of the check is a ground for an acquittal, which will be discussed in the next slide. So, in the case of Ruiz versus People, in this case, Ruiz issued this check against the offended party, Mendoza, and the Joey Bank dishonored the check as the account against which it was drawn was already closed. So this bank, where the offended party Mendoza had deposited the dishonored check, PNB notified Mendoza of the dishonor of the check. So they wrote through their counsel. They proposed letters that the drawee of the bank was already the drawee bank already dishonored the check, and so Mendoza demanded for the payment of the amount of the check plus interest. So when Ruiz received the letter from Mendoza, she promised Mendoza that she would pay for the amount of the check. However, Ruiz renegade and failed to pay. So Mendoza then filed a complaint against Ruiz in the office of the barangay chairman. Despite due notice, though, Ruiz failed to appear during the scheduled hearings, and consequently, the office of the barangay chairman issued a certificate to file action. So Ruiz was charged with violation of BP22 in the Municipal Trial Court of Camarines Sur. What was the main issue in this case? So the main issue in this case was the fact that the account against which the subject check was drawn does not belong to herein petitioner and thus contends that she did not violate BP22. So Ruiz says that since the bank account doesn't belong to her, she is not in violation of BP22. The court ruled in this case, though, that BP22 covers any check which bounces. It does not matter that then that the subject check belongs to the accused or another person. The ownership of the check should not be material in the determination of liability for violation of BP22. Otherwise, unscrupulous people may just start drawing or issuing checks of other people with insufficient or no funds at all, knowing that they will not incur criminal liability by employing such scheme. The importance of arresting the proliferation of worthless checks need not be underscored. The mischief created by unfunded checks in circulation is injurious not only to the payee or the holder, but to the public as well. This harmful practice can very well pollute the channels of trade and commerce, injure the banking system, and eventually hurt the welfare of the society and the public interest. The gravamen of the offense punished by BP22 is the act of making and issuing a worthless check or a check that is dishonored upon its presentation for payment. It is not the non payment of an obligation which the law punishes. It should be noted that even an accommodation party is liable under BP22. An accommodation party is one who has signed the check without receiving value in exchange and who issues the check for the purpose of lending his name to some other person. So, in this case, it was actually Ruiz who also signed the check, despite knowing the fact that the bank account belonged to her sister. So, the next case is Dumagsang versus Court of Appeals. So, in this case, the petitioner approached the complainant, which was a vice president of Metro Bank, to ask for financial assistance. So this vice president Garcia accommodated the petitioner and gave the latter a loan in the sum of 500,000 plus. So it was actually 573,800 pesos. In 800,000, 573,800. In exchange, petitioner issued and delivered to the complainant 18 post-dated checks for the repayment of the loan. So when the checks were in time deposited, the instruments were all dishonored by the Joey Bank. That says that the account is closed. So the complainant demanded for the calling for the payment and calling a petitioner at her office. Then, failing to receive any payment for the value of the dishonored checks, the complainant then referred the matter to his lawyer, who supposedly wrote petitioner a letter of demand, but the latter ignored the demand. So, of course, they already filed for the violation of Batasan Pambansa Bilang 22. And the main issue in this case is whether or not an alleged verbal demand to pay is sufficient to convict the petitioner for the violation of BP22. So the court's ruling in this case was pursuant to Section 3 of the Batasan Pambansa Bilang 22. The court is convinced that both the spirit and the letter of BP22 would require for the act to be punished. Thereunder, not only that the accused issued the check that is dishonored, but that likewise the accused has actually been notified in writing of the fact of dishonor. The consistent rule is that penal statutes have to be strictly construed against the state and liberally in favor of the accused. While indeed Section 2 of BP22 does not state that the notice of dishonor be in writing, taken in conjunction, however, with Section 3 of the law, that there were no sufficient funds in or credit with such jewelry bank, such fact shall always be explicitly stated in the notice of dishonor or refusal. A mere oral notice or demand to pay would appear to be insufficient for conviction under the law. So here in this case, the court said that evidently the appellate court did not give weight and credence to the assertion that a demand letter was sent by a counsel of the complainant because of the failure of the prosecution to formally offer it in evidence. Courts are bound to consider as part of the evidence only those which are formally offered, which in this case they did not. So for judges to base their findings strictly on the evidence submitted by the parties at the trial without the written notice of dishonor, there can be no basis considering what has heretofore been said for establishing the presence of actual knowledge of insufficiency of funds. But however, in this case, the accused was still liable for the payment of the amounts in the said checks, of course. So we go now to the last topic. It's the difference of estafa from BP22. Because in estafa, you can also be when you pay a check that is subsequently dishonored, you can also be liable for estafa. So the fundamental differences between BP22 and estafa is the fact that deceit and damage are essential elements in Article 315, which is estafa in the revised penal code, but are not required in Batasang Pambansa Bilang 22. Under the latter law, BP22, a mere issuance of a check that is dishonored gives rise to the presumption of knowledge on the part of the drawer that he issued the same without sufficient funds and hence punishable, which is not under the revised penal code. So the other differences include the following: that number one, a drawer of a dishonored check may be convicted under BP22 even if he had issued the same for a pre-existing obligation, while under estafa in Article 315, such circumstances negate criminal liability. So the second is specific and different penalties are imposed in each of the two offenses. And the third, estafa is essentially a crime against property, while violation of BP22 is principally a crime against public interest, as it does injury to the entire banking system. And lastly, violations of Article 315 of the revised penal code are mala in se, while those of BP22 are actually mala prohibita. So can you sue for estafa and BP22 at the same time? Or alternatively, well, the answer is yes. The simultaneous filing of BP22 and estafa cases do not amount to double jeopardy. While the filing of the two sets of information under the provisions of BP22 and under the provisions of the RPC as amended on estafa may refer to identical acts committed by the petitioner, which is paying for a check that is subsequently dishonored because of insufficiency of funds. The prosecution thereof cannot be limited to one offense because a single criminal act may give rise to a multiplicity of offenses, and where there is variance or differences between the elements of an offense is one law and another law, as in the case at bar, there will be no double jeopardy because what the rule on double jeopardy prohibits refers to identity of the elements in the two offenses. So otherwise stated, prosecution for the same act is not prohibited. What is forbidden is prosecution for the same offense. Hence, the mere filing of the two sets of information does not in itself give rise to double jeopardy. Essentially, while a BP22 case and an estafa case may be rooted from an identical set of facts, they nevertheless present different causes of action which, under the law, are considered separate, distinct, and independent from each other. So, therefore, both cases can proceed for their final adjudication, both as to their criminal and civil aspects, subject to the prohibition on double recovery. Perforce, a ruling in BP22 case concerning the criminal and civil liabilities of the accused cannot be given any bearing whatsoever in the criminal and civil aspects of a related estafa case. And so, them being separate acts, estafa and BP22, being distinct and also independent from each other, you can definitely file for an estafa case and a BP22 case at the same time. So this ends our discussion on Batasan Pambansa bilang 22. Thank you for listening. Good afternoon.